Mr. Sloven.
Thank you, Mr. Chief Justice. May it please the court. Counsel, good morning. It's good to be here. I want to start by saying that when the jury was impaneled and sworn on June 26th, the defendant was brought to trial under Jones. The state lost its ability to move for a dismissal without prejudice and refile later. The recess was short, and a definite time and date for the commencement of the evidentiary phase was set.
All right, so if the state is unprepared to go to trial within 90 days, but you impanel the jury on day 89 for a week thereafter, you'd say that's okay?
I would say that, well, under Jones, I'd say the bright line of Jones, that's okay. And
Wow. I mean, that would be a subterfuge of the 90 days if that could be done.
well, I don't think so, as long as there's a definite date for the commencement of the evidentiary phase. And
Really? But haven't we said, I mean, that 90 days is a strict rule? We've said that you can't miss it by a little bit and so forth and so on. Wouldn't this give the state a tool to, miss it by 91, 92, 95, 105?
So I need to start by saying that reliance on this court's case law in our courts is not itself a sin. Relying on Jones as the law.
Yeah, but Jones doesn't stand for the proposition that you can, that I'm suggesting. Jones says that it commences ordinarily at the time the jury is impaneled, but it doesn't stand for the proposition that if the state is unprepared at the beginning of trial, that you can get a little general person's extension based on swearing in the panel. It doesn't stand for that proposition at all, I don't think. I mean, I don't read it there. I mean, and you've got all the other federal and state case law to the contrary, where if you're trying to avoid speedy trial, if you're using it as a strategy for speedy trial, it doesn't work. I mean, I'm just having trouble with the scope of what you're suggesting.
Sure. So I think that Jones defines what it means to be brought to trial, which is what the rule requires. Now, if this court does want to adopt a lip service type analysis like we see in Gonzalez and Scaife and the other federal case law, I'd suggest that the determination of whether this is an attempt to pay lip service or if this is an attempt to truly vindicate the speedy trial right depends on a few factors. One of them is the length of the recess. Another is the whether the date set for the commencement of the evidentiary phase is definite.
Well, was this case brought into court that day for the purpose of having a trial?
It was brought for the purpose of commencement of trial with impaneling the jury and swearing them. And there is the state on June 16th when this is being litigated on the speedy trial issue says the state will offer to provide witnesses and commence the evidentiary phase on the day when we swear in the jury.
Right, well, the trial commences when? After the jury's selected, impaneled, and what, the information's read or whatever?
I would say that under Jones, it's when the jury is impaneled and sworn. That's when jeopardy attaches, and I think that's when it makes sense to say brought to trial. The state loses.
The actual selection of the jury is not the trial, and that's not bringing the case to trial. So that doesn't satisfy speedy trial when they're selecting the jury, is that right?
Under Jones, just voir dire itself doesn't. The federal case law actually goes further than that and says we want to erase the incentive for defendants to stonewall during voir dire, and we want to protect against unforeseen circumstances that make it take longer. So voir dire is when the Speedy Trial Act in federal courts is satisfied. Jones sets out a different rule, and that different rule is followed here.
Okay, so when the jury's brought in and they're going through voir dire, the case has not yet been brought to trial, correct?
I'd say that's correct under Jones.
Okay, and so when the court then impanels the jury and then lets them go, you're claiming that's when it was brought to trial?
Right, and I think that the crucial
At that
underpinning
moment,
of,
was there any intent on proceeding with the trial? Doing anything more than just selecting the jury?
so based on the conversation that had happened earlier and the exercise of the trial court's discretion into scheduling within the trial itself, no. They hadn't planned to present, by the time they got there on June 26th, they hadn't planned to present any evidence that day. Now, the state had offered to do so earlier, and the court had said, we're going to start the trial on this day, and then in my exercise of discretion, I'm going to call a recess so that all of the evidence can come in together. I think that that's a good point to talk about the good cause showing here. What the state showed on June 16th is that Dr. Saluk was going to be in Europe from June 23rd to 30th. Dr. Trevis was going to be performing neurosurgery. Dr. Neiman, that's the radiologist, was also going to be on duty.
The doctor's schedules are more important than somebody sitting in jail, is what you're telling me.
What I'm saying is that the absence of material fact witnesses, the absence of key witnesses, which would preclude the state from being able to make the...
But that testimony could have been preserved by deposition and presented before the doctor left town. It's done all the time in court, where they take depositions beforehand, and they take video ones now. At least when I practiced 13 years ago, they did video, and you play the video to the jury, and the doctor's there. I mean, it seems to me that the doctor can't be there, and someone's sitting in jail. And when you weigh those two, I mean, a guy enjoying Europe versus someone sitting in jail doesn't make a lot of sense to me when there's other alternatives.
So the first thing I'd say is that none of those alternatives were raised by anyone below. There's
Well, you have the burden, don't you, if you're showing just cause? Don't you have to show that you couldn't do the deposition? And don't you have to show you couldn't subpoena them, too?
So the state has the burden of showing good cause for delay of speedy trial. That's actually that's one of the reasons why it matters whether we adhere to this rule from Jones or whether we adopt a lip service analysis and find lip service or an intent to vindicate, because it matters as to who has the burden for showing the reason or sufficient reason for delay. I think that the defendant has reasons or would have reasons for wanting the doctors present in court for cross-examination over a video deposition, and I don't think that was really explored here.
Sought to subpoena anybody, I don't think, is there in the record?
That's correct. I don't think that there are subpoenas for these doctors.
And there's no evidence that you sought to preserve anybody's testimony, at least in the record. We should stick to the record here, I imagine, right?
That's right.
And this doctor that was in Europe did not testify ultimately, right?
So I need to make some clarifications on this, and part of it is that I think that the absence of one key witness, one witness who would be important for the state to prove its case, is itself good cause. I also and that's from Peterson.
You had seven medical. You identified 7 medical witnesses to testify in this trial. At the end of the day, only one did. There was 400 pages of medical record that came in. It strikes me that the state was unprepared. By the time trial occurred, you limited your testimony to one doctor, Dr. Treves, I think. On June 16th, you say, well, we've got 7 total medical experts to testify the guy got hit on the head with a sledgehammer and had the CT test and all this kind of stuff. And you were able, once you sorted through the case and were ready to try it, you only needed one medical expert. I mean, it looks like, and I'm giving you the opportunity here, but it looks like, well, what's going on here? 7 medical witnesses to testify for what's basically undisputed medical fact, and there's 400 pages of medical records?
We charged attempted murder. We got assault inflicting serious injury. I would say we needed more than we had. Dr. Saluk had, and there's more than one way of proving serious injury, obviously. Dr. Trevis is...
But you went to trial with one doc, right?
Right, and I think that shows more of an intent to honor that speedy trial right and that set definite date for the commencement of the evidentiary phase. When that day rolls around, and this is something the state actually knew on June 26th, it knew that some of its doctors would still be unavailable for that July 7th date. The conversation that happens at the end of the hearing is, look, here are our 4 witnesses. If we intend to call more, we'll tell you, but at this point, we know that we're not going to have Dr. Saluk or Dr. Neiman. Now, Dr. Saluk did the follow-up. This is really important, the treatment and the follow-up with Mr. Browning. And that's important to talk about impaired functioning, which is one of the alternative routes to serious injury. Another is skull fracture. That's something that Dr. Trevis, and I guess Dr. Neiman would have been good for that too, as the radiologist who did the CT scans. So we've got those 2 different routes to serious injury that the state was intending to establish. Not to mention...
Does it make a difference that the parties expected this case to be resolved by a plea, and then everyone's surprised when the defendant doesn't take the plea?
It absolutely makes a difference. And this goes to the question about the state being unprepared, that at one point there was an offer communicated, I think, June 2nd, sometime before.
Sorry, I'm having micro trouble. Can you hear me all right?
Yes.
Yeah, June 2nd, the written plea bargain, as I understand the record, was offered a week before trial, right?
Well, a week before a date that was
First trial.
labeled a trial date, but there were no motions in limine filed before that, no pretrial conference. It may have been labeled trial. It looks clear from the record that the parties intended that to be a plea date, or at least a date for satisfying what the plea negotiations.
What does the record show on all that? I mean, it wasn't a trial date?
Well, it shows that there's no jury there when they're called. It shows that, and Ms. Zacharias says at the sentencing hearing or the post-trial hearing that she had communicated with the county attorney on that, and they knew, or the county attorney was filling in, and they knew that that was intended to be a plea hearing. And the record also shows no motions in limine, no pretrial conference.
County attorney there on June 9th.
So I know that there's no name on the front of it. Ms. Zacharias was on vacation. I know that the practice in Potawatomi County when a county attorney is absent from a hearing, so if it's a trial, there's going to be somebody covering it. If not, then when the state's involvement is required, and all the Potawatomi County attorneys who are there.
I guess I'm just asking whether the state was there on June 9th.
Not in the record. Yes, the state had attorneys in the room because all criminal trials or jury trials in Potawatomi County go on Tuesday, either go or plead. Other Potawatomi County attorneys had trials on that day and were in the room to stand and get involved on behalf of the state if involvement on behalf of the state was needed. It wasn't here because all we had was defense attorney clarifying that, look, I expected my client to take this plea, and he hasn't. And it's also in the record that acceptance, or the intent to accept, had been communicated, at least by defense counsel, to the state. And when that happens...
When did that happen?
We don't actually know a definite date. We know it was at least June 8th or before. And that's from the statements in the resistance to the post-trial motions and at that hearing.
It could have been June 8th.
It could have been June 8th that was communicated. If it hadn't been communicated at all, I think the state would have gone there and expected to clarify its offer and talk about it, and then set trial for June 23rd.
No objection was raised to June 23rd as a trial date then.
That's true. Now, I think that at the point when the intent to communicate the offer, when the intent to accept the offer is communicated, at that point, whatever witnesses had been noticed that they needed to keep June 3rd open for testimony, those witnesses would have been told that obligation had evaporated.
Is there any evidence that the doctors were ready to go on June 9th? Or is there any evidence of any communication with any witnesses?
Well, we know that nobody was ready to go on June 9th, not even defense counsel.
I guess I'm wondering, you had a trial date. Was anybody subpoenaed for the trial date? I take it we don't know. I don't think.
We don't know, and I think that there's a reason why they prefer to request doctor's attendance rather than subpoena them to avoid failure to appear or any problems associated with that. But the
period between the 9th and the 16th, is there any evidence of effort by the state to subpoena witnesses?
There's evidence of effort by the state to contact those witnesses. Ms. Zacharias says very clearly that as soon as she gets back to the office, she reaches out to all three doctors about their availability and confirms and gets the information that she relays on the 16th, and then reiterates throughout that Dr. Saluk is in Europe, Dr. Trevis is doing scheduled neurosurgery, Dr. Neiman is also on duty with radiology commitments.
Where is the law that doctors get special privileges with subpoenas?
I don't think there's law about it. I think that there's an understanding that when you have witnesses that provide crucial and needed services, that can contribute to them.
When I practiced law, when they wouldn't come, I had to subpoena. They had excuses. They were going to do surgery. They had an office practice. Or they had something else, and I ended up subpoenaing them if I needed them for trial. I mean, we're in the law, especially when someone's in jail. Does a doctor have this special privilege?
I don't think that the special privilege is really the problem here. I think the problem is that there's a commitment of a nature that I think that we would agree that if somebody is scheduled to receive neurosurgery and needs it, that is an overriding consideration that justifies a short delay, like in this case. I mean, if the jury's
In those
impaneled on a Friday,
situations, when that happened, we would go take a deposition in the evening or during a lunch hour early in the morning because the trial was going on. I had one trial where the doctor was coming from Chicago. His father had an accident. He couldn't come. The court ordered us to fly to Chicago that afternoon, take the deposition, and come back. I mean, I don't understand why the doctor's testimony is unavailable when there's so many different ways to do it.
So I think that most of those different ways are going to require some sort of cooperation from the defense, and if the defendant is unwilling to extend that cooperation, then we're back to the same situation. I also think there's value to getting the doctor into the courtroom, especially if we're going to get other evidence about the events that took place and about the nature of the injury, and then suddenly they need to adapt to that. Doing a pre-conducted deposition is kind of not as useful in those situations. But I also want to emphasize that everybody thought, or at least the state and the court thought, that they could comply with Jones and commence the trial and then actually vindicate the cross-examination or the confrontation right by bringing the doctor into the courtroom and then having them, and Dr. Trevis spent more time on the stand in cross-examination than in direct. I think it was very important for the jury to see that cross-examination of Dr. Trevis to establish, and they ended up rejecting the idea that a natural consequence of the injury that was inflicted was death. Here, they acquitted on the attempted murder charge, so they rejected the inference that with a hit of that nature, the defendant intended to cause Mr. Browning's death. Now, maybe that conclusion would have been different with more witnesses. We don't know.
Counsel, if the state wins this appeal, do we have to worry about a de facto extension of the 90-day time limit? Does it become 100 days? People can wait till the last minute and then start and stop the trial and get an extra week or so? Is that going to become the practice? Or is this case pretty unique to its circumstances?
And if I can respond, thank you. I think this is very unique to its circumstances. Obviously, I mean, every judge to speak on this issue in this case says speedy trial is an issue that makes our ears perk up, and we're very attentive to it. I think that efforts are made to vindicate speedy trial in whatever way is consistent with the law, and to not take chances on that front. And I see this, if this court adopts a lip service analysis with and gives guidance as to circumstances where a short delay between swearing in the jury and commencing the evidentiary phase is appropriate, I think you can predict seeing district courts follow and perform that analysis religiously and use it as a last resort. Thank you.
Mr. Sloven, thank you as well. Mr. Stone. And welcome.
Mr. Chief Justice, may it please the court. My name is Corey Stone. I'm a second-year student at the University of Iowa, and I'm representing Mr. McNeal today. The state cannot use bifurcation to circumvent Iowa's speedy trial rule. Mr. McNeal was not brought to trial within the 90 days required by Rule 233-2B because the state was not ready, willing, and able to proceed with the presentation of evidence at the time of voir dire.
A difference that there were indications that your client was going to plead, and he changed his mind in court on June 9th.
No, Your Honor. First, the state's own admission on page 17 of the appendix is that they were under the impression that the defendant would probably accept a deal. In Taylor, this court has said that to some degree the state accepts the risk that the defendant won't accept a deal when it hasn't been finalized. But I think it's also important to consider that Mr. McNeal, when Mr. McNeal rejected the state's offer, it was the 9th, and the state still had 19 days. The state had 19 days to attempt to take a deposition, to
Deposition is a problem, right, unless your client consents, isn't it?
Sure, Your Honor, but there's no indication that Mr. McNeal wouldn't have been willing to take part in a deposition process in order to vindicate his speedy trial rights. At the hearing on the 9th, Mr. McNeal was very clear. He was adamant to proceed to trial as quickly as possible because, like Justice Wiggins pointed out, he was incarcerated. And I think that's what makes the speedy trial right so important in this context, is that Mr. McNeal was...
The court never gave your client the opportunity for a continuance or a deposition, because the state never presented it to them, did they?
Exactly, Your Honor, exactly. I mean, they never had the opportunity. And so for opposing counsel to suggest that that the defendant would have been unwilling to cooperate, or that Mr. McNeal would have been unwilling to cooperate, I don't think there's any evidentiary support for that contention.
Mr.
Well,
Stone,
your client wasn't ready to go to trial on the 9th either.
No, not on the 9th, Your Honor, but that still left 19 days of the speedy trial period during which trial could have been conducted, and the state similarly was not ready to proceed to trial on the 9th.
Mr. Stone, you're asserting that the state was circumventing the speedy trial rule. Did the trial court have a role in this as well?
It did, Your Honor. The trial court essentially took so for example, the opposing counsel mentions how at the trial level the prosecutor said, well, we could put on maybe a little bit of our evidence, but because our doctors aren't ready to testify, we'll have to take a break at some point anyway.
So the prosecutor was asserting that he could go to trial, put on some evidence, but then he would be at some point asking for a continuance to allow the witnesses to come at a later date.
Exactly, Your Honor. Bifurcation would have come up at some point anyway.
Well, what's wrong with that? That happens all the time. It's trial scheduling. Witnesses are available, they're not available, we adjourn.
Sure.
Happens every day.
And I think that's an excellent point, Your Honor, because it raises a critical distinction in the definition of brought to trial that we are advocating for, which is that in the normal situation, in a typical situation, the state, it's not an issue that the state isn't unable to proceed. In Jones, the issue of bifurcation wasn't considered because it wasn't a situation where the state was unable to proceed. In those normal situations, it's either not a situation where the state isn't able to proceed, or it's not a situation where the state waited until there were 13 days left of the speedy trial period.
Well, let me ask you this question. If the trial court would have required the trial to commence by calling witnesses, and the state's called all the witnesses that they could without the doctor's testimony, and then moves to continue the trial for 7 days or 10 days to allow this other witness to come, would you have a speedy trial argument?
I think it would depend on some of the facts of that scenario, Your Honor. I think that if the state had made a diligent attempt to get those witnesses scheduled and they simply were unable to, then yeah, that would have, of course, constitute good
trial
cause.
court, by deciding to continue the trial until a later date, obviously thought, don't we have to imply that the trial court felt that there was a good reason to continue the trial?
Well, Your Honor, of course, this court should defer to the trial court's findings of fact unless they're not supported by substantial evidence, but the legal conclusion that the trial court drew from those facts, which is that good cause existed, does not enjoy the same level of deference.
How about a doctor in Europe who's at least the state believes is going to be essential to the presentation of the case? Is it unreasonable to say, well, to Rome to do the deposition?
I think prosecutors should jump at the opportunity to fly to Rome to take the deposition, Your Honor, but...
Maybe we can hold court there, too.
Yeah.
But seriously, the state maintains at least that the medical testimony was of a critical nature, but particularly with respect to Dr. Salud, I maybe mispronounced the name. That's the person who was in Europe. And, you know, a small accommodation of 11 days to allow the physicians to be scheduled. Isn't scheduling matters good cause to extend the speedy trial deadline?
No, Your Honor, I don't think it is. I mean, first of all, the state knew from the outset, from the initial filing of the trial information, that Dr. Saluk was listed. And the state was similarly aware that medical personnel can often have scheduling difficulties. But instead of acting immediately, with foresight and in knowing that there might be difficulties in scheduling these witnesses, the state, by their own admission, waited until the 15th, which was 13 days before the speedy trial period lapsed, to begin working diligently, and that's in page 200 of the appendix.
But it seems like the trial court gave the prosecutor a pass on that, because the trial court could have said, no, we're going to trial, and you're going to present whatever evidence you have. But the trial court didn't make that choice. The trial court looked at it and appeared to be trying to manage the situation by saying, well, we got a 90-day problem. We've got to start this trial. It doesn't do any good to call a couple witnesses and then continue it. And so the trial court was obviously implying that that would have happened. And so the trial court said, no, we're just going to wait the 11 days and then we'll start calling all the witnesses. Isn't that just a management decision and not a speedy trial issue?
Well, it might be a management decision, Your Honor, but I think if it's a management decision that results in a violation of Mr. McNeal's speedy trial rights, then it's one that this court needs to reverse.
Well, was the trial court trying to evade the 90 days or just trying to manage the circumstances that the judge was presented with?
I think the trial court was, I certainly don't think that the trial court was intentionally trying to evade Mr. McNeal's speedy trial rights, but I do think that the prosecutors were unable to proceed and that the trial court was, I guess, the trial court enabled the state to circumvent Mr. McNeal's speedy trial rights.
What you're saying is what should have happened in this case is back in March, the prosecutor should have forced the court to give it a definite trial date in June. Is that what you're saying? And gotten those medical witnesses confirmed that they would be available in June if the court had been willing to do that. Is that what you're saying?
I don't know that that would have been the only solution, Your Honor.
Really, what else is there? What's the alternative solution?
Well, if had the state known that, for example, Dr. Saluk was going to be in Europe, they could have taken a deposition. They could have, ultimately, they didn't need Dr. Saluk's testimony anyway, which I think is significant in the hearing. The reason that good cause was found specifically was that Dr. Saluk would be in Europe. Dr. Saluk was ultimately not called. The prosecutors even suggested the July 7th date, premised on the idea that Dr. Saluk would be available on that date. And just quickly, while we are discussing the issue of the doctors that were available to testify, opposing counsel has suggested that they didn't get a conviction of attempted murder because they didn't have enough medical witnesses. They didn't get a conviction on attempted murder because it raised an issue of intent, and certainly medical witnesses wouldn't have been able to testify as to intent. The only medical witness they ended up calling was Dr. Treves. Dr. Treves the record doesn't suggest he was in Europe. It does suggest perhaps he had to perform neurosurgery.
Which is an important thing, right?
Oh, absolutely.
I mean, that's a legitimate reason not to be available to testify, right?
Yes, Your Honor. It's a legitimate reason not to be available to testify on a specific day, but it doesn't in any way implicate Dr. Treves' ability to have performed a deposition in the lead up to trial.
Well, is there any showing that Treves wouldn't have been available on the 26th of June, which would have still been within the speedy trial deadline?
There isn't, Your Honor, and in fact, the record shows that the prosecutors were well aware on the 25th that they wouldn't be calling Dr. Saluk and should have proceeded to the presentation of evidence and proceeded with trial on the 26th when they were aware of that.
Shouldn't we give deference to the trial judge that's got the front row seat for all this, and to the trial court's call on that there's good cause, and the judge has to manage the trial docket? Why should we reverse here?
Well, Your Honor, I think that's a great question because it raises the issue of what the precise standard of review is in this case. And it's not just the typical abuse of discretion. This court has said the standard of review is circumscribed discretion. And this court in multiple decisions has cited the American Jurisprudence of Criminal Law second, which says that all doubts are to be resolved in favor of the accused. This was clearly a situation where some doubt about whether good cause existed, or where some doubt about whether or not the state had acted diligently in getting these witnesses scheduled was raised, and therefore it should be resolved in favor of the accused in favor of Mr. McNeal.
What evidence did the state put on about how long this brain surgery was?
They-
How many days it was gonna take? How extensive was his surgery schedule?
I'm very glad you asked that, Your Honor, because they put no evidence on. The trial court accepted a bare assertion, and this court has said a bare assertion that doctors or that witnesses would be unavailable is not enough for the trial court to accept.
Some brain surgeries don't take very much time at all. If you're gonna relieve a subdural hematoma, that's drilling a hole and draining the blood.
Yeah.
Some where you have to go get a deep tumor may take longer, but was there any evidence of the length, the time, the number, things like that?
There was not, Your Honor.
Counsel, the state has suggested that the rule it is advancing in this case, allowing for bifurcation, commencing the trial within the speedy trial deadline, and then finishing the case at some later time, is not likely to create a circumstance that undercuts the right to speedy trial, because judges and lawyers will act properly and move things along. Do you have a different view?
Well, Your Honor, if we simply trusted the courts and lawyers to comply with the speedy trial rights, there wouldn't be a need for the rule in the first place. We would simply say that there would be a rule of criminal procedure that said do speedy trials well, and period. And then we would have no mechanism for redress when the speedy trial rights were violated. I mean, I think the reason that there is a procedural bright line rule in this case is to avoid that situation where we simply rely on trial judges and prosecutors to honor the rule for the sake of honoring the rule.
Just so
Jones,
just so I'm clear, so your position is that we just have an absolute rule that everything must be tried, you must be commenced, the trial must be commenced, and in fact take place all within the 90 days. Is that what your position is?
No, Your
So we
Honor.
just have the bright line rule, and then we never have to worry about it. I got the impression, I thought that's what you were saying.
No, Your Honor. I'm sorry. I'm sorry to have given you that impression. The rule that we are adopting, the definition of brought to trial that we are advocating for, is that all parties must be ready, willing, and able to proceed with the presentation of evidence at the time of voir dire. I think that's a relatively easy rule to apply.
Unless there's good cause.
Unless there's good cause, of course, Your Honor. Unless there's good cause, so it would still leave room for situations where there is good cause, and while avoiding the issue of bifurcation. And one last thing I'll say about Jones, because Justice Mansfield, I believe you were going to ask a question about Jones. In Jones, I think it's relevant that this court based its interpretation on a California case, People v. Katzman, which was interpreting, it was a late 60s case interpreting California's speedy trial rule, in which California said voir dire satisfies the rule. And I'm running over time if I can conclude. But since then, California has explicitly overruled People v. Katzman. It has adopted a rule wherein there are certain elements of what it means to be brought to trial, and all parties and the court being ready, willing, and able to proceed to trial are all essential elements, and that in the absence of those elements, you have not been brought to trial. And that was both in Reinhart and in People v. Hajjaj. So thank you very much.
Mr. Stone, thank you as well. Mr. Sloven, rebuttal?
Thank you, Mr. Chief Justice. May it please the court. Let's talk about Taylor for a moment, because there was some discussion of this case. In Taylor, the court reiterated what it said in State v. Lamar. In Lamar, the plea negotiations extended over more than a 2-week period. The state, under the impression there would be a guilty plea, as a result, and in reliance on that, the case was not set for trial. Good cause for delay. When the case isn't set for trial, the witnesses don't preserve their availability, especially when they have important professional medical treatment obligations. Neurosurgery is in very high demand. This is the kind of thing where the state, so even if and I appreciate Justice Mansfield, you pointing out the problems associated with trying to set a trial date as early as March. Even if that had happened, and even if the state had told these witnesses to preserve their availability on June 23rd, as soon as the negotiations advanced to a point where it was communicated to the state that there was going to be a resolution through a plea, those witnesses would have been let free from that obligation to preserve that date, and they would have scheduled.
Well, really? I mean, there's probably going to be, I mean, the record, and I know you'll correct me, but it suggests that there was probably going to be a plea, but you're going to release witnesses until you actually have a plea agreement?
I think their understanding was strong enough in this case. On page 4 of the 616 transcript, our understanding was that we had a deal. Defense counsel says he thought that the defendant would accept. Everyone involved seemed to be under the impression that that on June 9th they were going to take a guilty plea.
Counsel doesn't accept a guilty plea. He thought his client would accept. The client has to accept it. It's different than saying, my client will accept it, instead of, I thought he'll accept it. You can't practice law, either in civil or criminal case, on the come as to what the client may or may not do, your best guess, because after 30 years, they don't do what you think they're going to do a lot of times.
I mean, in this context, we're relying on each other's professional statements all the time. The state is relying on what defense counsel says about the defendant's intentions, and the court is relying on both sides' professional statements about what the client intends to do and the witness's availability. And so to this idea that there's nothing in the record supporting the fact that these witnesses actually were unavailable, there certainly is. There's professional statements from the state about...
But yeah, they're kind of conclusory, aren't they? I mean, there is some suggestion, okay, we have a neurosurgeon who does brain surgery. When, what day, can he be available at noon? Can he be available at 4? Can we work them in Tuesday? What about even keeping the jury at 5 o'clock? Maybe we'll keep them a little longer, those kind of things. Instead, we have, I think, correct me if I'm wrong, but we have kind of a generalized statement. Well, we're juggling around with the schedule. They have important things to do.
And I do
am I
wish...
mischaracterizing the record? I mean...
What she says is that he's in neurosurgery that week. I do wish we had better record on what exactly those obligations were, but I think that it's fair to rely on the statement that if she says that he doesn't have any availability that week, and the court credits that...
Oh, she didn't say that.
Certainly Dr. Slook is in Europe the whole time. And I think this all comes back to the circumscribed abuse of discretion standard. And I really think it's important to clarify what that means. I think it's best said in Olson, the Court of Appeals case in 1995, I believe. This court's cited it many times. We recognize the trial court's discretion to refuse to dismiss the case within parameters of the recognized exceptions that can show good cause. So what circumscribed abuse of discretion should mean here is if the trial court says there's good cause for delay because it's beautiful outside and we all want to go outside, obviously that's an error at law. But if the trial court says, I found good cause for delay because of witness unavailability, we review that finding for abuse of discretion and we credit its findings. We defer to those findings when it says, this attorney has told me that these witnesses are unavailable and I believed it.
Mr. Sloven, if we just focus solely on the 90-day rule and the purposes of the 90-day speedy trial rule, how are those purposes served when the trial only consists of assembling the jury and discharging them, sending them home to a later date beyond the 90-day speedy trial rule? Isn't the defendant in the same position that he was before all of that happened?
He is not in the same position, Your Honor, and the reason is because jeopardy has attached. The state has lost its ability to dismiss without prejudice and refile later, especially when a definite date for commencement of the evidentiary phase is set. The defendant is relieved of the anxiety associated with a suspended prosecution and knows that there is a date certain when the case will be tried through to conclusion. And it's the same as what a defendant would experience who faces a 2-week trial when he faces an 11-day recess and then a 2-day trial that is certain to commence no matter what happens. Thank you.
Mr. Sloven, thank you as well. And Mr. Stone, I know Mr. Sloven would appreciate this comment because he was a student intern several times and argued before this court, but we all want you to know that you did a very nice job this morning. The case of State versus McNeal is now then submitted to the court, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.